Senate Judiciary is now in session. Senator Reardon will lead us in the pledge. Allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice.
Is he here today, or is it-
He's here.
He is.
We're going to start with Senate Bill 267, an act relative to the penalty for engaging in prostitution as a patron. Senator Fenton from Keene, my good friend, go ahead.
It's good to see you, my good friend, Mr. Chair, and members of the committee. For the record, I am Senator Donovan Fenton. I represent District 10, and I'm here today to introduce Senate Bill 267, legislation aimed at strengthening our efforts to combat human trafficking and exploitation in New Hampshire. This bill is being brought forward as part of a broader effort to combat human trafficking, working alongside advocacy organizations like World Without Exploitation, which is committed to ending exploitation. This bill would establish a $500 fine for individuals who engage in prostitution as a patron, in addition to any other existing penalties, and direct those funds to the Victims Assistance Fund. The purpose of this legislation is twofold. First, to act as a stronger deterrent against individuals purchasing sex, and second, to provide critical resources to support victims of exploitation. We know that where there is demand, there is also supply, often created through force, fraud, or coercion. By imposing a stricter financial penalty on those who fuel this industry, we can help reduce demand and, in turn, diminish the market for human exploitation. New Hampshire has a well-earned reputation as a safe state, but human trafficking is not just an issue that happens elsewhere, it is happening here as well. You will hear compelling testimony today that highlights the real and present dangers of this issue in our communities. We have a responsibility to take proactive steps to address it. Senate Bill 267 is a common sense measure that will hold the buyers accountable and direct much needed resources to support our survivors. I would urge the committee to vote to pass on this legislation and send a clear message that New Hampshire stands against human trafficking and exploitation. Thank you for your time and consideration. I'm happy to take any questions.
Sure, just two quick ones. I'm unfamiliar, and Senator Abbas was also, with the Victims Assistance Fund. Mm-hmm. Is that a long-standing group I just don't know of?
I believe it's established in our New Hampshire. It's a fund established through the legislature for the New Hampshire Victims Fund, yes.
Okay.
Yeah.
And so currently there's a criminal penalty for engaging as a patron, and there's no money at all involved in the penalty?
No, there is money involved in the penalty, but it's not directed towards the New Hampshire Victims Fund.
Okay.
As I understand it.
Thank you, Senator.
But it could be proved wrong.
Any other questions? Great. Thank you, Senator.
Thank you, Mr. Chair.
You have a great afternoon.
You too.
I will try. We're going to limit it just so we can get out of here by 6 or so, and I got a lot of big bills. If you can keep it to 2 minutes, it would be good. If in any way, we read everything. I'm going on vacation. I take this whole stack, and my wife's like, what are you doing? I'm like, I'm reading this stuff. So we will read any testimony you have. So if you can talk to us, works a lot better than if you're reading. If you can't, you're nervous, fine, just read it. That's fine. I'm not looking to play hardball. But again, if you can try to keep it to 2 minutes. Thank you. Abby Fabiaschi? I'm good with Irish names. Italian names I'm a little weaker on. So if you could say your name and where you're from.
Okay, sure. Yep. My name's Abby Fabiaschi. I'm a New Hampshire resident here today on behalf of Empowered Network in support of Senate Bill 267. I co-founded Empowered Network in 2017 to collaborate with survivors of sex trafficking beyond the crisis to achieve their personal and financial self-sufficiency. I've been active in the movement to end trafficking and sexual exploitation for over a decade and can share confidently that trafficking looks a million different ways, but rarely how it's portrayed in the media. Yes, there are instances where people are handcuffed to a bed, but far more often, universal needs that we all have, like the need for connection, food, and a place to sleep, are weaponized and exploited by traffickers and buyers for profit and pleasure. When anyone is vulnerable, everyone is vulnerable because a business has been created and the people making money will always find enough supply to fill a lucrative demand. Empowered Network has a wait list of survivors in every location we serve. There are a lot of statistics that will be shared today, but the one that keeps me fighting for positive change is 13. That is the average age girls are sex trafficked in the United States. So imagine at 13, someone burning your birth certificate and declaring they owned you. that would feel like a fact. And everyone can shudder at that image because the trafficker is such an obvious villain. But traffickers don't exist without buyers. And if 13 is the average age, it's because there is a market to have non-consensual sex with young girls. One of our lived experience staff members was once asked by a board member about the buyers. She said, I can't imagine it. Who are these men? And the staff member's response was immediate. It's your cousin, your friends, people who look and sound and dress like you, everyday people with a dark side. We cannot gloss over the buyer's role in sexual exploitation. The problem literally would not exist without customers. SB 267 is a thoughtful approach to curbing demand by charging sex buyers with a fine that helps to finance services and support for survivors at a time when funding for victims is scarce.
Thank you very much. That was great. Any questions? Seeing none, thank you. Audria Duty? Was doing better last time?
And it's an Irish name too. I'm shocked. So my name is Audra Duty. Good afternoon. Thank you, members of the committee. I'm Audra Duty. I'm currently living in Worcester, Massachusetts. I'm also the co-executive director of Safe Exit Initiative located in Worcester, Massachusetts. We provide support. We're dedicated to providing resources and support for people impacted by the sex trade. I'm here today in support of SB 267 to discuss the urgent and critical issue that impacts our communities, the need for demand reduction in the fight against sex trafficking. I stand here today as a survivor of the sex trade. I want to share a little bit of my story and why I wholeheartedly support the proposed bill to impose mandatory fines on those who purchase sex. I moved to New Hampshire when I was 15 years old. I was already struggling with trauma in an unstable household. I soon found myself placed in the system. I went to multiple group homes and state facilities throughout the state. I was in these programs from age 16 to 17, and when I was 17, I felt like everybody had given up hope on me and lost all faith, and I was sent to a Job Corps program in Massachusetts. As a teenager, I was lost and vulnerable. I was placed in the system and shuffled between group homes. Instead of finding safety and support, I experienced neglect, isolation, and trauma. It was during this time that I was approached by individuals who claimed they wanted to help me, but in reality, they wanted to exploit my vulnerabilities. It started with my manager at one of my first jobs right before my 18th birthday. I didn't know what I was signing up for. All I knew is I wanted to belong and find some sense of safety. The first date I went on, I really didn't know what I was doing, and I felt so disgusting and dirty after that transaction. Before I knew it, I was shuffled all around to all these fancy places throughout New England and the East Coast. When I was in the life, I felt invisible, objectified, and less than human. The buyers that came in to see me treated me that way. Almost every rule or agreement that I had was almost always broken. I spent more time with the buyers than any pimp or trafficker. And that caused a lot of harm. I still have nightmares to this day. I struggle with finding healthy relationships. I wonder how my son, who's 15, who lives in Nashua currently, will respect and love me for my story. So I really urge you to take this bill into consideration. Thank you.
Thank you for your testimony. Stacy Reed. Afternoon, Ms. Reed.
Good morning. Good morning. Thank you for having us today. My name is Dr. Stacy Reed Barnes. I'm here today in support of Bill SB 267. I have over 20 years of experience in human trafficking awareness, prevention, and survivor support. Not only as a professional in the field, but also as a survivor who has lived through the very exploitation we are discussing today. I deeply appreciate this opportunity to testify about the urgent need to address demand as a core strategy for reducing harm, trafficking, and sexual exploitation. Human trafficking exists because there is a demand for it. As someone who experienced firsthand the devastating impact of this industry and is currently working directly with survivors trying to rebuild their lives, I know that those who purchase sex are not simply engaging in a transaction. They are fueling a system of abuse, coercion, and suffering. Every day, I see demand is not just a theoretical strategy. It is a necessary and urgent intervention to break the cycle of exploitation, protect the vulnerable, and shift the culture that allows trafficking to persist. As a member of the Human Trafficking Community Research Hub at William James College, my research and lived experiences consistently show that demand drives much of the violence in the sex trade. When we examine arrest records, demographic data, and income disparities, it is evident that buyers who are overwhelmingly men are often in positions of economic and racial privilege, while those being bought and sold are disproportionately from marginalized communities. This imbalance highlights the deeply rooted inequalities within the sex trade. We have seen that financial penalties such as fines and fees imposed on sex buyers are effective deterrents. Jurisdictions that have implemented these measures have not only reduced demand, but also generated funding to support services for survivors. Given the dire need for more resources in the space, utilizing these funds to provide housing, counseling, and job training for those exiting the sex trade is both practical and just. Sex buyers are not ignorant of the harm they cause. The reducing demand directly reduces trafficking. When buyers are deterred, and the incentive for traffickers to exploit individuals diminishes. This is a proactive approach to prevention, one that not only disrupts the market for commercial sexual exploitation, but also shifts the burden of accountability onto those who sustain it. The need for funding survivor services is urgent. We have an opportunity to use fines and fees from buyers to invest in the life-saving programs that offer real pathways to freedom and stability. By curbing demand and redirecting these funds to essential services, we can make a tangible impact in the fight against human trafficking toward wholeness and healing for survivors. If you please, I urge you to support policies that target demand, hold buyers accountable, and fund services for survivors. Thank you for your time and commitment to this crucial issue as we move forward to combat human trafficking to live in a world without exploitation. Thank you.
Thank you, Dr. Reed. Wow, do we have a question if you'll take it?
No, thank you, Mr. Chair. For the Abby, Audria, and Dr. Burns,
Dr. Barnes.
Barnes,
Yes.
sorry, Barnes. If you would like to submit your testimony to the clerk to be entered into our report, that would be awesome.
Thank you.
Yeah, please do. Thank you.
Ashley, is it St. Agers? You know, I was gonna guess Staggers, and then I'm like, okay, got the S, T. Good afternoon. How you doing today?
Doing good, doing good.
Good.
We are
Thanks for
good.
coming.
Thank you, members of the committee, for taking the time to consider the testimony on this important legislation. My name is Ashley Staggers. I'm a policy associate with Rights for Girls. We're a national human rights organization based in Washington, D.C., and I'm submitting testimony today in support of SB 267. At Rights for Girls, we work to end gender-based violence among vulnerable young women and girls across the U.S., including right here in New Hampshire. We do so through policy and advocacy, research, coalition building, and technical and training assistance. We have also worked extensively to shed light on the importance of confronting demand for commercial sex, a critical means of sex trafficking prevention. Across the country, prostituted women and girls bear the brunt of legal consequences associated in the sex trade, while the men who purchase them largely enjoy impunity and anonymity. Nationally, women account for 62% of adult prostitution arrests, while girls for roughly 71% of youth arrests, even though legally they're considered victims of child sex trafficking. Even when children are bought and sold, the consequences for buyers are minimal. A report shared by Shared Hope International revealed that in 134 cases of men purchasing sexual acts from minors across the country, 26% served no time and 69% of all sentences were suspended. The disproportionate punishment of survivors is concerning, especially when considering the extraordinary level of trauma that they endure at the hands of buyers and exploiters. According to a Colorado medical study, the mortality rate of women in prostitution is 200 times the rate of the general population. Physical violence committed by exploiters and traffickers, but most often by sex buyers, includes sexual rape, rape and gang rape. More specifically, 92.2% of women in the sex trade report being subjected to rape, shot, strangled, beaten, burned, stabbed, or punched. Prostituted women also report being urinated, defecated, and ejaculated upon, forced to have unprotected sex, and subjected to the insertion of foreign objects in their bodies. One recent study found that 98% of prostituted women surveyed that they had been raped by their sex buyers or pimps. Given these horrific acts, it is not surprising that 68% of prostituted women meet the criteria for PTSD, as severe as the levels of PTSD suffered by combat veterans and victims of state torture. SB 267 would hold sex buyers accountable in their anonymity and help curb the demand that keeps this violent system churning. This bill would additionally help provide services for survivors of trafficking, allowing them the opportunity to move beyond their trauma and rebuild their lives. Therefore, we ask the members of the committee to please stand with survivors and pass SB 267. Thank you.
Thank you for your testimony. Any questions? Seeing none, thank you very much.
Thank you so much.
Is it Lee Casagrande? Good afternoon.
LJ Casagrande. Good afternoon, Mr. Chair and members of the Senate Judiciary Committee. My name is LJ Casagrande, and I'm here to testify in support of Senate Bill 267. As a former resident of New Hampshire and a survivor of trafficking and exploitation in New Hampshire, I feel due to this it's only my right I should be here to speak on this bill. Too often, survivors are overlooked. The harms and traumas we have been through are disregarded, while our abusers and traffickers are let off with no consequences. If it were not for the services and organizations led by survivors, many of whom are here today, I most likely would not be standing in front of you today. Too many people who have gone through exploitation and trafficking don't have the services available to them that they need because of lack of funding due to make more services available. Because of this, many survivors go back into exploitation. The passing of Senate Bill 267 would help ensure that more people are able to exit exploitation and live the type of lives they were always meant to live. Lives free from exploitation. Thank you.
Thank you very much for your testimony. Thank you. Senator Sullivan, we're probably 20 minutes from you, just so you know.
Thank
you. Alexandria Powell. AKA Alex.
Yes.
How you doing today?
Good, thank you. Thank you, members of the committee. My name is Alex Powell. I'm a longstanding resident of Nashua, New Hampshire. I'm a community case manager, with Save Exit Initiative. We're an organization that provides resources and supports for individuals that have been impacted by the sex trade, those with lived and living experience. I'm queer, I'm also non-binary, I'm a person in long-term recovery, and I'm a survivor of the sex trade myself. I'm here to offer testimony in favor of SB 267. This legislation is critical for holding patrons, i.e. buyers, accountable for their actions. As we know, prostitution and exploitation is a form of violence that's largely driven by demand and by those with power and disposable income buying access to the bodies of marginalized and vulnerable individuals. In my role as community case manager, I've worked with folks all across New England, including individuals that have been trafficked in New Hampshire and exploited in New Hampshire. I think this is an opportunity for New Hampshire to set an example for the region of New England by showing that this is an unacceptable form of violence to be happening and that it has real consequences. I think it's really important for the fees to go back into services. There is a distinct lack of services in New Hampshire. I've witnessed this first and second hand, and I lost personally a close friend to this violence in Nashua. So I myself have been trafficked and exploited in New Hampshire and in multiple states across New England. I've suffered from PTSD, complex PTSD, relapse, chronic medical conditions. It's been a lifelong healing process, and it's affected, my human interactions on any level, really. Those who oppose this, might argue that this makes prostitution more violent by targeting quote unquote consensual clients, but the reality is this is not an industry. It can't be looked at as such. It's those in power buying access to the bodies of BIPOC and LGBTQIA2S+ individuals, those with substance use disorder, experiencing homelessness, significant disabilities. We can't afford to look at this as another industry, but the violence that it is. Other people have mentioned this, but buyers, are the most likely to use fatal violence against survivors. But yeah, I ask you to support SB 267. Thank you.
Thank you. Matt Patch. Good afternoon, Ms. Patch.
Hello, Chairman Gannon, members of the committee. I'm Barb Patch from Merrimack, and I also am the director of All Girls Allowed, a nonprofit who fights sex trafficking and exploitation, as well as a member of the New Hampshire Traffic Free Coalition. We fight exploitation every day. Buying sex isn't like buying a product. However, many buyers see it that way. They ignore the human being in front of them and pay for time with a body. And what they do with that body may shock you. You've already heard from our colleague over here that the horrors that prostituted people face, and yet many of them cannot speak up or fight back because their traffickers or pimps will punish them if they get bad reviews by the Johns on John boards. And so many are really stuck. There's a story of the homeless teenager in Boston living on the streets. And a man approached her, do you want an apartment? He took her, showed her a beautiful, warm apartment, and then the twist came. I'm going to take you back to the street, and you have to bring back $1,000 if you'd like to stay in this apartment tonight. This is the reality that a lot of these people are facing who are being exploited. And under the current New Hampshire law, RSA 645-2, buyers and prostituted people receive the same charge of a misdemeanor. Other things that get a misdemeanor in New Hampshire are nonviolent. Marijuana, possession, disorderly conduct, shoplifting, simple assault and battery, trespassing, vandalism, resisting arrest. That's what gets a misdemeanor. But these people who are prostituted are enduring some real horrors. And that's why we're here. New Hampshire has kind of a mixed review in how well we've done at arresting buyers. A couple of studies, very quickly, you can find them on Google. In 2015 was an arrest. 1 buyer and 5 prostituted people were arrested. 2023, 4 prostituted people arrested, no buyers. So we beseech you to give these survivors a chance and help the buyers and be accountable.
Thank you very much.
Thank you.
I'm sorry, Senator Abbas has a question.
Sure.
Thank you, Mr. Chairman, and thank you for taking my question. You mentioned that it can be the solicitation or paying
Yeah.
paying for the service would be a misdemeanor.
Yes.
Which means,
Under the current law.
and it's not classified as an A or a B misdemeanor. In a Class B misdemeanor, it has no possibility of jail time. Do you have any opinion on whether perhaps the law should address making it a Class A misdemeanor?
I'm not as familiar with like A and B situation. I know it's different too if you're prostituting adult versus a child. So, that plays an impact. But
That's a felony, but what I'm saying is if it involves 2 adults,
yeah,
then
right.
it's really discretionary of the prosecutor to
Yeah.
prosecute as an A or a B. But with a Class B, there's no potential of jail time, where Class A, there is a potential for jail time.
Yes, we would love to see the jail time, and we are of the belief that buyers out there choosing and seeking this, many of the survivors who are enduring it are just out of fear or the need for home, home food, or they're being controlled with drugs and other things, that there's such an inequity in the punishment. They both get the same charge, but yet one is enduring real exploitation, the other is perpetrating it. So that's why we'd like to see that for the buyers.
Thank you.
Thank you very
Thank
much
you
for
for
your
the
testimony.
question.
Tricia, Grant? Good afternoon, ma'am.
Good afternoon. Good afternoon, Mr. Chair and members of the Senate Judiciary Committee. My name is Tricia Grant, and I'm here representing Just Love Worldwide in Maine. We strongly support Senate Bill 267, an essential initiative aimed at reducing human trafficking and supporting survivors. To begin, I want to emphasize the critical role of demand in perpetrating the commercial sex trade. Demand fuels much of the violence inherent in what can rightfully be called the rape trade. The buyers who drive this market are responsible for sustaining a cycle of abuse, and by holding them accountable, we have a unique opportunity to dismantle the very foundations of trafficking. There is a glaring inequality between buyers and the individuals who are bought and sold. Demographically, buyers often wield significantly more power and privilege compared to their victims. Disparities are visible in terms of income, ethnicity, and even in arrest rates. Despite being the primary perpetrators of this violence, buyers frequently face far fewer legal consequences than those they exploit. Senate Bill 267 seeks to address this imbalance through a proven approach: fines and fees levied on those who buy sex. This approach has dual benefits. Economically, it generates funds that can be directly channeled into vital support services for victims who desperately need them. It also serves as an effective deterrent, sending a clear message that buying sex is not a crime without consequence. Curbing demand directly leads to a reduction in sex trafficking. By reducing demand, we strip the commercial sex trade of its profitability and allure for traffickers, ultimately protecting countless potential victims from exploitation. On a personal note, this cause matters to me deeply. As a survivor of trafficking, I was trafficked here in New Hampshire and throughout New England as a 15-year-old. For 16 years, I remained silent because I did not understand there was a name for what was done to me, nor that it wasn't my fault. Over the past 12 years, I have dedicated myself to understanding this issue, listening to other survivors share their stories and pain they have endured, and working with advocates to fight for change. I also run our first diversion program in Maine for sex buyers. We've had 52 men come through our program and learn about what it was that brought them to a place to think it was okay to buy sex and to talk about the real issue. This is not a victimless crime. In conclusion, I urge you to pass Bill 267. It is a concrete step towards both decreasing demand and supporting those affected by trafficking. Together, we can create a safer, more just society where all individuals are free from exploitation. Thank you for your time and consideration.
Thank you very much. Seeing no questions, have a great day.
You also.
Elisa Bernard. Good afternoon, ma'am.
Thank you to the chair and members of the Senate Judiciary Committee for considering SB 267 today. My name is Elisa Bernard. I do more than just take pictures. I'm the Deputy Director of World Without Exploitation. I'm here to testify in support of SB 267. I'm not going to talk a lot about the things that you've already heard. I appreciate your time in all of that. We actually first came into New Hampshire a few years ago when an indoor prostitution bill had been put forward in opposition to that, and we appreciated the committee's ability to understand that issue at that time, and we hope that that can continue forward now. SB 267 is a mechanism that I've seen implemented in other states, and in short, it works. In 2013, Washington State, where I'm from, created a fee structure similar to the one proposed in SB 267. And while Washington State is a much larger state and its fee is much steeper than the $500 fee proposed in this legislation, its initial success really does speak for itself. Within a year of that legislation being enacted, one county was able to pay for a transitional housing program for survivors. And in its second year after implementation, Washington State assessed $153,000 in fees from patronizing prostitution alone. All of those fees, well, not all of those fees, a portion of those fees went to nonprofits providing services to trafficking survivors. Even if we account for the difference in state size, that's still a sizable amount of potential money. As someone who ran one of these nonprofits in Washington State, I can tell you that these funds helped people heal and exit prostitution. Many of them are alive today because of those fines and fees. To be honest, no one should have the right to purchase somebody's body for sex because from what I've seen of the survivors I've worked with, far more of them enter the trade because they need to or because they are forced to, not because they want to. But people who choose to purchase sex are doing so only because they are choosing to purchase sex and because they want to. So when you take sex buying seriously, you take trafficking seriously, because if there was no one purchasing sex, there would be no one buying, there would be no one being trafficked for sex. No buyers simply means no business. Thank you so much to the committee. If you have any questions, I'm happy to answer them for you.
Thank you for your testimony. Seeing none. Thank you. Thank you all. Very brave, strong women. Do you want to see if you can get Senator Rivard to just do this now? No, you want to do it. Okay. Does anyone else wish to testify who didn't have a chance on 267? Seeing none, we'll end the hearing. Yeah. No. She may or may not be back down. I'm thinking that he might want to. I'm sorry, I'm taking Carol. Look, as he was talking about punishment more, I think he may have want to make it more. But I was waiting. If we just, he's right there. And Okay. Okay.
And so this is
Yep.
dedicated.
Good idea. I just, yeah, I hadn't heard of it. Okay. Okay.
Is.
Okay. Yes. Do you want to see if, just exec this now, unless Daryl's having an amendment or something? See if you, I'd do it right now if he's coming. Who is? I don't need her, but, I need Daryl. Yeah, I would exec it unless he's like adding an amendment. Yeah. What's that? I think they're right there.
Senator Addison.
Nope.
I didn't word the question properly.
Yeah.
Motion to move into exec.
Second?
Thank you. All in favor?
Aye.
Motion for ought to pass.
Second?
Okay.
267.
I'm sorry. Yeah, the one we just did.
Well, Lisa, just stick.
Okay, discussion. Senator Abbas.
So if I may, and I asked a question about making something
Yep.
Class A. The way I asked the question was probably not the best way, because I think it would have applied to the entire section.
Mhm.
But if we're really focusing, if the bill's really intended to apply to, the Johns.
Yep.
If you go to RSA 645:2, Roman numeral I, then F. And that, I'll just read it, pays, agrees to pay, or offers to pay another person to engage in sexual contact as defined by RSA 632-A. Lists a bunch of, it's basically, that's the John section. I think, although I think the answer to my question was, that so they supported Class A, I think they meant only the John section. I clarified that in the hallway.
Yeah.
Okay.
No,
So if we can do a
Is
committee.
that the intention? Like,
Yes, so well, the way I can tell by the way I asked the question, that may not have been, so I clarified that, so I guess as,
so you wanted to go to F?
if you go to F,
Yeah, pays, yeah, agrees to pay
You-
or offers to pay. And you want to increase.
we can make that a Class A misdemeanor, as opposed to the other sections remaining just a misdemeanor, so it can be an A or a B, it's the prosecution's discretion. But an A would be, a Class A misdemeanor would apply to Section F.
Is there penalties on Class A are fine and or time?
Well, if you
What's
adopt,
the minimum or maximum on A?
should we just do an amendment on the floor? We would have more time to think about it.
Oh, we just, we
Okay.
we do it like.
Oh, I was just
yeah,
trying
we
to-
can-
so if we,
Move
if
the
we.
roll.
Okay, you know what the
I'm fine
minimum-
waiting.
Like, the penalty is on A? Fine
Well,
and time?
It's not a mandatory jail sentence, but it's just a possibility.
Right, yeah, that's what I mean, it's like, what's the possibility that's open to the judge's word?
So the bill as presented.
Up to a year, okay, thank
but-
you.
But the fine would be separate, so the amendment, the original bill would still be unchanged, but you would also have, on top of what you could have this fine can't be suspended, where some fines can be. This one.
Right, well, this one says it can't be suspended, and also, just you know, I don't think we teased this out, but it's per conviction. So this is not one event. It's however many
Sure.
events, so, which, great.
And I spoke with the great senator who sponsored the bill. I think he was supportive of the potential.
Really?
The only change would be, so RSA 645:2, Roman numeral I, F, then paragraph F. The amendment would just make that a Class A misdemeanor, as opposed to the rest of the section remaining just a misdemeanor, so it can be an A or a B.
Can I make just a suggestion about formatting that?
Yep.
Roman 2 is the one that makes it a class A felony if the victim involved is under 18. So maybe this becomes a new Roman 2, that a violation of F is a class B felony.
Yep. We'll screw it up. Yep. So we'll do an amendment. We will do this.
We can-
We're
Yeah,
all
can we
in favor
put
of
this,
this.
I can do
put
it.
into OLM?
Well, I can do a form. Yeah, I'll write it up and so it's all clear, so we'll do a
Okay.
form.
Sure.
No,
All right.
you guys, you don't trust my work?
Understanding what the
No.
intention is, like we're all on
Yeah,
the same page.
we're all on the
with
same
that. Yeah,
page, all
okay,
in
good.
agreement.
Yeah.
We'll just pass this now.
So we're looking to put it
We ought to
under,
pass. The whole bill?
in that bin.
Okay.
Well, it has an F. Why don't we move because it's an FN?
I want to move it and then add.
And if I,
Yeah.
I can do it on, if
Yeah,
I,
we can
if I can
consult.
mastermind.
He has
it in
great
time.
confidence
Throw
in himself.
around, just pass around an email with the,
It's one of the few things I think we all agree on.
Yep.
yeah. Like, let's
Okay, Pete,
roll with
so
this
we're going back.
moment. Yeah.
So we have not to pass motion. All in favor?
Aye.
Move consent?
No consent.
No
No
consent.
consent. Yeah, we're gonna talk about it. Okay. Do you want to take it out there?
Sure.
Yeah.
Sure. Okay. Okay.
Motion to move out of exec.
Motion to move up. Sure.
Good time.
We'll
What
do
time
one.
is it?
We got to keep moving. We'll do SB 48 FN relative to the company competency to stand trial for certain offenses. I have an ITL motion. Do I have a second?
Second.
All in favor? Or do you want to discuss? I'm sorry.
Don't move.
What's that?
Sit down.
I should let her sit down. You're right.
Yes. What's, we're doing
48
48.
competency.
I thought we maybe were gonna retain it. Or does this have to be a do-over next year? Like,
I think it should be a do-over because I think what you want to work on would be a completely separate thing.
well,
Okay. Okay. So we have a motion for ITL. All in favor of the ITL motion?
Aye.
I,
I'll take it up.
40,
What's that?
40.
Move for consent.
Oh, I see. Okay. Motion for consent?
Yes.
Yes.
Second.
Consent, Alistair?
Yes.
Oh, you did. I didn't hear you. I'm sorry.
No, my bad. I
All
was
in
too
favor?
short, too
Okay.
quiet.
So the ayes have it, 4-0. Motion for consent?
Second.
All in
Second.
favor? Yep.
Aye.
Okay.
Motion to come out of executive session.
I'll
Who's taking
second
this
it.
out?
Okay, so we motioned, I second. All in favor of moving out of exec?
Gannon.
Aye. Okay, 262. I'm sorry. Senator Sullivan, come on up. We're trying to exec anything we can in between here. Good afternoon. Good to see you.
267, right? 267.
If I'm late picking up Seamus, I'm just blaming you, so.
Go ahead, Senator.
Okay. Thank you, Mr. Chairman, members of the committee. My name is Senator Victoria Sullivan. I represent Senate District 18, which is Manchester wards 5 through 9 and the town of Litchfield. I'm introducing Senate Bill 262FN, and this is a very straightforward bill. We already have minimum penalties for child trafficking in law. This just changes what those minimums are. Current minimums are 7 years for a minimum, and that is far below what even Congress has passed at 15 years. And our maximum was 30 years, and I have changed this to life. So the 18 years is actually symbolic of every year of childhood that's robbed from these children. And then, of course, the life sentence is the maximum. So I'm happy to take any questions. It's a very straightforward bill. And I think it's long past due that we had harsher penalties for people that want to harm our children and make New Hampshire inhospitable to people that want to come here and harm our kids.
Any questions? Seeing none, thank you, Senator.
Thank you.
Pam Kelly.
Good afternoon, Mr. Chair, members of the committee. My name is Pamela Keilig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. The coalition is the umbrella organization for our state's 12 community-based crisis centers, which provide free and confidential services to nearly 15,000 survivors of sexual and domestic violence annually, including survivors of human trafficking. I'm here to testify in support of SB 262, which increases the penalty for trafficking children in New Hampshire. Thank you for the opportunity to speak today. As you've heard this morning or this afternoon, human trafficking is a very complex crime, and research and practice has shown that comprehensive state policies that include protections for victims and harsh penalties for crimes can be an effective deterrent for human trafficking. For instance, the House is currently working on a bill to increase penalties for those who operate illicit massage parlors, an effort that the coalition also supports because we know that traffickers have fled to New Hampshire to operate these illicit businesses after our neighboring state made their penalties have increased the penalties. The coalition, as you might know, coordinates New Hampshire's Human Trafficking Collaborative Task Force, which is a multidisciplinary partnership between law enforcement agencies, prosecutors, healthcare professionals, children's services, victim services, and community partners throughout the state. The task force seeks to improve the statewide response to human trafficking, and as a result has worked hard over the past decade to develop a robust response to human trafficking in our state, including efforts over the past decade to strengthen our state laws. And we're very grateful that the legislature continues to take a strong stance on this issue. Trafficking activity has been identified in every county of our state, with victims ranging in age from very young children as young as 3 and into those who are the elderly. The forms of exploitation also range from forced and coerced agricultural labor to forced prostitution, with the majority of identified cases involving sex trafficking. In 2023, our crisis center supported 81 victims of human trafficking, and 11% of those, so about 9 of them, were children. And in 2022, there were approximately 91 reports made to DCYF Central Intake specific to human trafficking, involving 95 children. So this unfortunately is something that impacts our children here in the state. Crimes of human trafficking are devastating to the victim and their families, and it's important to hold individuals who engage in trafficking accountable. So I appreciate just the committee taking consideration of this bill, and I'm happy to answer any questions.
Thank you. Seeing no questions, have a great day. Does anyone else wish to testify on SB 262 who didn't sign up, or seeing none? We'll adjourn the hearing. Do you want to? Yeah. Sure, I understand. It's going to cost a lot of money. Sure. We'll just feed them smaller meals, smaller cells. Sure. What's that? Yep. Do I just put it through now and we'll give it to Cindy, correct? Yes? No, we'll do something. Yeah. Yeah, I know you are. I understand that. It is. But you're okay with doing it. Okay. I understand. Senator Abbas, we're going to exec this bill if you're ready. I'm sorry, Agati, did you want to speak? I'm sorry, Benjamin. I haven't really closed it. Am I okay? Okay. Oh, it's the next one. Oh, they're getting ahead of me. Okay. I motion we move into executive session.
Second.
Any discussion, or I'll just introduce not to pass motion
Okay, where's Bill?
on 262 that we just heard. Okay. A vote on the exec. All in favor, say aye.
Aye.
Aye. Great. Motion brought to pass. Senator
Second.
Evans, thank you very much. Any discussion? I know your concern, Senator, and I'll take that up with the appropriate senator. Otherwise, all in favor of the ought to pass motion? Aye.
Aye.
Motion for consent?
Second.
All in favor?
Aye.
Senator Reardon, would you like to take this out? Great, thank you. No, we'll just in one at a time. Seems to work good.
Motion to come out of executive session?
Thank you.
Second.
All in favor?
Aye.
Aye. Okay, we are out. 148. Senator Sullivan, it's your afternoon. I can see that. Okay, let her roll.
Thank you. Thank you, Mr. Chairman, members of the committee. I am Victoria Sullivan. I represent Senate District 18, and I am here to present Senate Bill 148 FN. So this bill prohibits those convicted of murder from financially profiting from the death of the victim. It came to my attention that we are one of only 2 states in the country that do not have any bill like this that protects people from victims' families from watching the murderers of their family members profit from the crime. So this is often referred to as the Son of Sam legislation, and you may be familiar with that because New York had a hard time getting something to stick. This language here is what has been the language that has held up through scrutiny through the courts. It does not violate the First Amendment right, which is what New York came up against, and New York kept at it. So they got the language that actually worked and held up. So this is very similar to that language. And again, this came up through conversations about what happened with Harmony Montgomery, who is the little girl that is from my district, and the fact that her father could benefit from murdering his daughter. So it's long past due that New Hampshire had this law. It's a shame that we waited this long. Like I said, Vermont is the last state standing that does not have something like this once we get this passed. And I'm happy to take any questions.
Senator Oster.
Thank you, Mr. Chair. Thank you, Senator Sullivan. Has Adam Montgomery entered into a contract to benefit the murder of his daughter?
I'm not familiar with that.
Just following up on what you just asserted, so.
I said there's nothing that would keep him from doing so.
But he hasn't,
Not to the
there's no book deal that we know of or.
I am not
television
privy
special.
to his
Okay.
financial. No,
Seeing no other questions, thanks. Senator Sullivan.
thank you.
Mr.
Good afternoon, sir. Good afternoon, ladies and gentlemen. My name is Benjamin Agati. I'm a Senior Assistant Attorney General. I'm currently the Chief of the Homicide Unit of the Department of Justice, where I have been working since 2006. The Department of Justice does not take any official position with regards to this particular legislation. I think one of the reasons that General Formella asked me to review it and come over was because it does deal with a very niche area, which happens to be the area that I work in, which is the area of homicide. I think initial impressions, I want to be able to do that, provide that to you, and then also be able to answer any questions that you might have about the effect of what some of this language would do. I think, first of all, speaking for the small amount of prosecutors in our office that do it, we are incredibly appreciative that somebody else is concerned about this problem besides ourselves. This is a matter, an issue where often where we might have a plea on a particular case, we can incorporate a particular clause that is built into a person's sentence to ensure that they're not able to profit in any sort of manner from the offense and telling their story in a variety of different ways. However, that is not a tool that is available to us if it's a matter where somebody has gone to trial and they've then been found guilty. That is not a matter that's something typically the court would enforce, nor would it have usually a method of enforcement. So a statute like this would address that gap that currently exists. When there's a plea, we can often put it in place. When there's not, that's something that's left up to the individual. And I believe, Senator, before I go on, I can answer your question. Speaking as one of the prosecutors on that particular matter, I do not know of any particular deal that he has, Mr. Montgomery has struck in exchange for his story or what's available there. That is also not something that he would be required to notify our office about, nor would he be required to notify the court. So while I don't know of any, and if I knew, I would certainly share that, I can't say that he's forced to tell us that that would happen. So I hope that addresses your question, I guess, just to start off. With regards to the language itself, and I really want to separate these into the two different components that have been proposed. First being RSA 562A, and then after that I'll address RSA 507I. RSA 562A, I think that, again, this is an area that there is a gap that does need coverage and does need attention. I do see some concerns with regards to the language that's there. And what that effect will be. And I think one of the things I'm hoping to be able to do is answer questions for you about different areas or clauses in here and what that would look like. Some of the language that was based upon the original New York legislation, that language has different meanings here in New Hampshire. And so I think I just want to make sure that senators and everybody are deciding this based upon knowing what this language would do in a New Hampshire court system as compared to elsewhere. That being said, I think I'll stop for a minute and I'm happy to take questions at any time or if there's anything in particular that senators would like to go through.
Thank you, Mr. Chairman, and thank you for taking my question. I interpreted this as, especially if it involves a family, they're disinherited on anything that they may, if they're beneficiary in a will or a trust, they lose all that. I'm not an expert on estate planning. I'm not sure how much experience you have with that. Would it just then pass down as if they've been deceased? Or what happens to that if they're the sole beneficiary of property? Clearly, this would have them disinherited. Would it then, where would that property then go? I mean, would it go back into the, I think the term is residuary clause? Or would it go to, like, as if they passed away, would it go to their heirs?
Well, first, it's an excellent question because that, and quite frankly, you might want to teach at law school because that is a perfect law school question, which is to say, okay, what's the residual next steps? I certainly don't have any specific interest in the area of estate law, but we can go back to some of the more basic property law and wills and trusts that I remember from my particular passage of law school. And what happens is sometimes within a will, there may be a residuary clause that dictates where those assets are going to go. Often in wills, there are clauses that are inserted that say that if somebody who is going to benefit from this estate plan is in fact the person who's the cause of the death of the person who's dying, then they have forfeited their portion and it gets shared out in different ways. But there is also always the other part of it, which is if a will is either found to be invalid or if a person dies intestate with no will and no direction, then we go back to the intestate laws that we have and we follow those laws, which are called levels of consanguinity amongst family members, and the probate court has to go ahead and make those allotments. So basically, there is a residual. That is actually one of the areas and one of the terms that I've noticed in here. If we look under, and we're staying here with the first part, right, with 562A, we talk about the ability of a person who's an interested person to be able to bring a matter in front of the probate court to have this adjudication take place. The term of interested person, as it sits in the statute right now, is not defined or not further defined. So whether that interested person is somebody that would ordinarily take under the will or somebody who would be able to claim something if they were part of the intestate share, or if we say that this is somebody who has a public interest in this death. I can think of one particular a former boxer who happened to pass away here, a very famous boxer who happened to pass away here in New Hampshire. Does this mean that a member of the public may be interested in what happens if they thought that there was some sort of foul play involved? All of those are possible when there's no definition for interested person. And without a definition, the court will then use common language to try to discern what interested person means. If there are other specifics, or if not, then I have a few areas that I wouldn't mind going through if you folks have time.
Senator Oshler.
Go right ahead.
If we were to amend in section 1 in definitions, define interested person, would that set off a cascade in other sections of law that we would have, that would, would also need to be adjusted if we put interested person as a specific definition to this chapter?
If you left it as interested person, I would probably say yes. But if you said for the purposes of this chapter, or for
Okay.
the purposes of this statute, interested person shall mean, then you've provided guidelines to the court and anyone along that this definition only applies here within this statute. It's not to be used elsewhere.
Thank you.
Senator Abbas's question was the A+ law student who's going to be the teacher. I'm the B student sitting in the back. So if you just
I'm
go
right next to
towards lines 19 and 22, it just bothered me a little, and I don't know why. On page 2, so if you don't have a conviction, the preponderance of evidence standard would be used to determine your guilt, like at a criminal level.
So
That bothered me.
I can certainly jump to that. What it essentially is doing is setting up a separate matter, and I just want to make sure that I'm looking at the same section. We're talking about under 562A6. We're talking about how it's determined.
Yes, sir.
So with that, if we did have that, you are changing your standard. So if we were in a criminal courtroom, the state has to prove beyond a reasonable doubt. Here, you're making it now that the petitioner, whoever that may be, whoever the interested person is, has to prove by a preponderance of the evidence. We've removed it from a superior court judge who may have heard these sort of matters before and knows those sorts of standards. Now we're in the probate court. And so we're asking a judge who may be unfamiliar with the different elements of the crimes, what does that look like? And how do I go ahead and go about making that? You are also creating a couple other things if you choose to go about that way. One of the things is talking about when it says in the absence of such a conviction. Well, does that mean necessarily that there is no prosecution? There's no prosecution that's ongoing, or that the matter remains unresolved and still being investigated? There's also no time period on that. So presumably what it could do is it could create a private cause of action for an interested person to say, I know it's only been 3 weeks, but I believe that this is the person who's responsible for the death. I'm going to go to probate court, I'm going to go file for my petition on this, and then I'm going to turn around and subpoena all of the investigative material that's there. That can cause a severe problem with the criminal investigation itself, because then information that may only be known to the person who is the killer has been disseminated and shared out. Certainly the court could consider whether to put a protective order in that place to ensure that only the petitioner would have it, but then the person that the person brings a petition against is also going to get that material. And then they know, especially if they are a suspect, they know everything that law enforcement knows that ordinarily they would not. This could occur whether it is 6 days after the death, 6 weeks, 6 years, 16 years. That is another thing that's created there. So I would say you have to consider whether or not that's something that you wish to do.
Okay, I interrupted you and you were rolling, so go back.
No, that's okay.
Okay, thank you. I'm sorry,
Go ahead.
Senator Abbas wants to bother you too.
So
On a hot
that,
bench.
on that topic, would it be maybe, although this would still, I can imagine, disrupt a prosecution, but maybe if there was a wrongful death civil claim brought, which you could, I mean, that's still available, even if it's an intentional act.
It certainly is. That's available now. That's available in the future as well. That still separately sits outside of the criminal realm. The ability to compel investigative material that could be used in an ongoing homicide investigation or on a later prosecution. I think that's the area, protecting those particular records to ensure that we could still bring prosecution. One thing that's also not laid out in this section of the statute is what is the effect of, the legal term is called estoppel, You may have heard the phrase res judicata, or you may have heard collateral estoppel in the past. One of the things that may happen here is when we think about the definition of estoppel, the estoppel is a determination that has been made by a specific court, a court of competent jurisdiction, over a matter or a set of facts. There's no clause as currently written in here that if the probate court finds that a preponderance of the evidence has not been shown in the private action, there's nothing there that would then say that a later superior court would not be estopped, collaterally estopped, from allowing the state to move forward with the prosecution. The idea being that a court of competent jurisdiction, a justice here of the New Hampshire court, has made a determination that these facts have not been met by a preponderance of the evidence. Then turn around, and the argument from a defendant would be in the criminal realm, I was shown and a court found that even by a preponderance of the evidence, I'm not the one responsible for this action. So the state is now stopped from saying, I did the exact same thing, but beyond a reasonable doubt. We don't see that happening very often. Sometimes in the homicide world, we've seen that where a person has committed an assault, they were tried, and later on, months later on, sometimes years later on, the victim died from that initial assault. If they were found not guilty of the assault, the state is stopped from saying that, well, they must be guilty of the homicide, because they would say, I was found not guilty here. It's very clear when all of these are just criminal matters and the state is the party. With the statute as written, it's unclear if estoppel would apply to a criminal action with a decision made by the probate court. I hope that made sense, and I see I've got another question.
Go ahead, Sandra. Yep.
Thank you, Mr. Chair. Thank you for taking my question. I want to use an example from my district many years ago. We had a person who murdered their wife and involved their I think he was a preteen at the time, teen son, in the disposal of the body. So does that, and the son was aware that the father had murdered his ex-wife. He's a minor at the time of the crime, not adjudicated as a party to the murder. Can he then be able to sell his experience, his story, his experiences?
As the law as it currently stands right now, he would be able to. There is nothing that is stopping him from doing that.
Right now, yeah.
Unless it was.
I mean, anytime he could right now.
Right, right now.
There's no look back, but we're going forward.
Right. If that same event were to occur today, unless it was written in, well, there's a couple different ways. Unless it was written into, let's say, a plea agreement where he's agreeing to not do that, that would be one way that he would be stopped from doing it. If he was an individual that was going to take something under her inheritance that was set up through her estate plan, and there was a clause in there that said, you shall not take if you participated, then obviously he would not as well. But there is no other operation of law that would say after he was convicted, that therefore he would be stopped from doing so. This would change that.
Okay.
Cinderad?
Thank you, Mr. Chairman. Thank you for taking my question.
Certainly.
This law, if we passed it today, wouldn't apply retroactively to murders that have happened?
Usually the court would interpret that unless there is a specific clause that has been written in to say that this shall be retroactive. Most commonly, the court would interpret and say, no, we were not going to make this retroactive. That's starting today.
Great. Thank you.
Thank you. Go ahead. Continue.
I think some of the other questions that I had in general, and certainly if any questions are generated by me making these comments, please let me know. If we start with the area of just straight with the language of a killer is somebody who feloniously and intentionally kills. When using the term intentional in a New Hampshire court, that's going to be interpreted as a concept of either purposely or knowing event. It does not include a person who has a reckless or a negligent mental state. So what that would do is that this would then apply to a person who may be guilty of capital murder, first-degree murder, second-degree murder under the knowing mental state, not under the reckless with an extreme indifference to the value of human life mental state. It would also not apply to manslaughters, which are a reckless mental state straight, or a negligent homicide, which are also under the homicide statute. And that is a little bit of a difference in between the two statutes. 562A6, the definition of killer involves that intentional death, whereas in 507I, it talks about anything that's under the chapter of homicide. So then that second degree reckless, that manslaughter, that negligent homicide come in. None of these would involve an overdose death that would occur under 318B17. In that case, it's a knowing intent to distribute that the law requires, not a knowing intent to kill. So if the Senate would choose to want to have those things included, amendments would need to be changed to add those other particular charges in. And maybe that could be a change either with the intentional or however the Senate would choose to do so. But there just be note that that is one thing that will be separate. One thing that's also not clear is whether the petitioner here would have to disprove self-defenses. And that could be justifications for intoxication, defense of others, thinking about a variety of them that might all be out there. Insanity, whether or not it was a voluntary act. It's not clear that the petitioner would have to disprove defenses like you would have to have in criminal court. That's something that the state would have to disprove, let alone what the burden for that is. And I would say one of the other aspects is the very last section where we're talking about 562A7 under 1, where we talk about felonious and intentional killing, how determined. There are two questions in there I just want to point out. One is that the language says, before the payor or other third party received written notice of a claimed forfeiture or revocation. From that, the one question is, where is that notice coming from? Is the petitioner then going to be expected to provide that notice to the payor, or is the probate court going to be expected to pay notice to the payor? And then you have the last section there where we talk about the court shall hold the funds or item of property. I do not know the judicial branch. They'll have to answer themselves whether they are equipped to be able to store that property. Here you've talked about assets which are not only intangible, but you're also talking about tangible assets. So that may be being prepared to safeguard a large amount of large items. Sometimes it could include furniture, vehicles, even animals, let alone the perishable goods that might be there. The probate court may ask you for a plan of how it's going to be storing these things or be able to do a disposition of these things, especially if they're perishable goods. I know homicide cases, I apologize, are probably some of the worst offenders on bringing physical evidence into the courtroom. We can take up an entire closet with the amount of physical evidence we might bring in for one particular matter. You might want to ask that particular judiciary what they would do to have the storage of those. I would say those are kind of just all the initial concerns of the reading through that's here, and I think it's just with additional language, but the intent in this really does cover something that has not been covered before.
Thank you for your testimony. Yes, go ahead, Sunder.
Thank you, Mr. Chair. Thank you very much for taking my question. Senator Sullivan brought up that the Son of Sam law, which anyone who followed the court, the battles on getting that in place, it was messy. It was difficult.
Very much so.
How can we learn from that and still stay within our constitutional obligations? New York has look backs. We don't have look backs. Where are we tight here in that we have learned from that? Do you see where the differentiations are between how New York did what they did and what this is here?
I can't say I've necessarily studied New York, but I'm fairly familiar with it only because, like I said, this has been a concern from our office for a while with regards to the homicide unit, what happens to the small group. And luckily, New Hampshire is a very safe state. We are talking about a very, very small category of offenses compared to what goes forward here. And that's a good thing for all of us. I would say that some of the pitfalls that can be avoided, a lot of other states have looked at it, and I think it's just some of the terminology, not necessarily the operation, that I think you would probably want to just address to make sure that that is meeting some of our other definitions and terms that we've used in New Hampshire. So again, I think it's more terminology rather than the process. The only last thing, if I could, just briefly, Senator, with regards to that second part of the statute, 507I, the program and the system that the legislature has set up for the Office of the Victim Witness Assistance inside the Department of Justice is of system-based advocacy. It is for advocates who are appointed to explain and go through the criminal justice system process with victims' families. They are not set up to be private advocates on behalf of individual victims or victims' families. And there's a distinct difference between the two. If 507I is passed the way that it's doing, what is being asked of those particular advocates is to now basically injecting a government function into what ordinarily would be two civil litigants. And I just want to make sure that the senators understand that that is what it would call for. Now you've got Department of Justice system-based advocates who are impartial in this entire process, being ones who are holding on to information and then sharing it on behalf of what is going to be a civil process going forward. I don't know whether or not the legislature wants to inject government at that particular stage. One of the other aspects is that covers all homicide crimes. Homicides is defined through RSA 630. With that definition as it's drawn, that also includes manslaughters, negligent homicides. The New Hampshire Department of Justice may occasionally prosecute a manslaughter and negligent homicide, but those are usually handled by the county attorney offices. So the victim advocates asked to be the go-between here have no relationships, no knowledge of those other victims' families or cases. It may be something where you wish to look to the county attorneys to involve them if you want prosecuting agencies to be there, or to look to a different part of an agency or a notification system. And with that being said, I thank you very much for your time today.
I thought I signed up. Sheila Koffold.
Any expert on estate planning would be convenient.
Good. Thank you, Chairman and members of the committee, for allowing me to speak today. My name is Attorney Sheila Koffold, and I represent Crystal Sari, who is the mother of Harmony Montgomery and her court-appointed administrator for Harmony's estate. Crystal could not be here today, but I'm here to confirm her support of the proposed New Hampshire Slayer Bill before you, Senate Bill 148. The lack of clear direction in this state on this issue is very unfortunate. The idea of having to go to court with a convicted murderer to try to convince a judge who has absolute discretion that said convicted murderer should not inherit from his victim is, simply unimaginable. However, the current state of the law here in New Hampshire requires exactly that. As attorneys practicing in this field, we start at the baseline that the culpable party may inherit from the victim. And then as attorneys, we are tasked with having to dismantle that baseline to prevent the inheritance. The burden is significant, to say the least. This arduous process typically occurs after a difficult and emotional criminal process, as well as an extensive and protracted civil process. And it is simply unfair and inequitable to put a family through such a grueling effort after suffering the tragic loss of a loved one. New Hampshire needs to do better for victims of crime and their families by passing this bill. Thank you.
Thank you, Mr. Chairman, and thank you for taking my question. Do you practice in estate planning or?
Estate planning and estate administration and litigation, yes.
And speaking for myself, I don't want to throw anyone else in the bus. I'm not an expert in estate planning, but is just from the procedural aspect of how this bill would work, do you see any procedural issues that maybe you want to offer a comment or opinion on? Because I think the concept of the legislation is not my issue. It's just, I think some of my lack of experience in estate planning. Will this work in the state of New Hampshire as it's written?
I believe it will work. I think the fact that it will direct us back into the statute when necessary will provide the necessary guidance when there's uncertainty. Right now, it's sort of up in the air, and anything can happen. I think Attorney Agati spoke to some of the issues and the flaws in the current system. But the biggest issue is the unpredictability. And at the end of the day, judicial discretion can go anywhere in these cases. And it's very difficult to counsel a family with what to expect, not only in outcome, but in the amount of time that these sorts of cases take to move through the system because of the lack of guidance.
And thank you, Mr. Chairman, and thank you for taking my follow-up question. I think I want to say, I knew I had it in here somewhere, it was about 3 years statute of limitations, what I saw of when the profit, is when they would have to bring the claim. I'm not sure if I read that correctly, but do you think that the time period of when, the civil case could potentially obstruct the prosecution side of things, should we put like a tolling provision in here to maybe allow that time not to be extended throughout if there's a pending prosecution?
I really can't speak to that. I think there is some tolling provisions in there that provide for, currently that provide for a case to be brought, depending on when the prosecution of the criminal, the criminal process is complete. I think that would provide some ability to extend the statute of limitations from when a case is brought if it is delayed due to that uncertainty.
And the last follow-up, I asked the previous witness, what would happen if, the person, they get disinherited. Now, would that automatically go into the residual clause, or would this operate as if they've been deceased? So like, for example, if one spouse murdered the other, maybe if that surviving spouse would have inherited everything, but obviously they're now disinherited, would it then go to the children? Or where does that, I guess, property interest go?
So the way the bill is written, it includes that it would be presumed that the person disclaimed their interest, so it would skip over that person. So if there were an estate plan in place, it would go on to the alternate beneficiaries named in a plan. With young children, there's obviously not an estate plan, so we have New Hampshire's intestacy statute. So we at least have some provision as to where that share that would have gone to the culpable party would go.
Thank you.
Thank you. We didn't even get into a rule of perpetuity, so I'm not confused. Thank you.
Thanks.
Oh, I'm sorry. Senator Reardon, I didn't see her over there.
Thank
Tried
you.
to be funny.
And thank you for staying for just another question. Do you have an opinion on whether it's better to use disclaim or predecease?
I do have an opinion on that. I tend to like the word predeceased better than disclaim, only because it's simply clearer and, just clearer than the disclaim, in my opinion.
Thank you. Appreciate it.
Thank you for your testimony.
I-
Did you have a question? Oh, sorry, one more. We're almost there.
That's okay.
I don't normally ask this, but being an attorney, I figured if we run into any other estate legal questions, is there a way
I'm sorry.
if we have any other estate questions that we, might have that we didn't even think of yet,
Absolutely.
if you don't
Please
mind
reach out.
leaving your office contact, that would be very helpful to.
Absolutely.
Thank you.
Happy to.
I'm hoping you don't have a big retainer, but that's okay.
No problem.
Thank you.
Thanks.
Does anyone else wish to testify on 148 who didn't sign up? Seeing none, we'll rest the hearing. Can we do a couple? Okay. How about we go into motion to go into executive session?
Second.
All in favor?
Aye.
How about we go to, I think are easy ones, 53 on the organic reduction of human remains. We'd like to offer re-refer at this time.
Second.
You okay?
Oh,
Okay.
yeah.
Okay.
It's still going. It can be more alive than what I felt. Okay.
Okay. On the motion of re-refer, all in favor?
Aye.
Okay, the ayes have it. Motion for consent?
Second.
Second, all in favor?
Aye.
Aye. I can take it out, it's fine. Okay, we're gonna move on to, we'll do the easier ones first. I think the easier ones. 146, a motion for ought to pass.
Hold on,
Do I have a second? I'm sorry. I'll stop.
You're taking out the last one?
Yeah.
Got that, all right. That's fine. 146?
146, the medical examiner certificates.
Yes. I
I have a
have,
motion about to pass.
You want to pass this one?
no.
Well, no, I can talk about it. Why don't we wait? I won't, can we talk first? Yes,
Yeah.
I'm gonna talk first.
So I have,
So it did make me nervous. I had,
can I pass that down to you?
I don't know, I watched too much TV, I guess, and I thought of,
It's a made for Dateline episode.
yes,
Yeah.
it's, some nurse doing her, mercy killings and then, writing it off. They just, that's what this is? Okay. So it did give me second thought, and then I thought I was just being paranoid. So maybe I'm not. Maybe there is something there, so I'm certainly willing to discuss it.
I don't think you were being paranoid. And we heard in testimony from the medical examiner that they were not adequately staffed
Yep.
to do all of this. I don't know that changing the law is a good reason. Like not being staffed up is a reason to change the law instead of like, maybe they should be in front of finance asking to staff up
Sure.
instead of relinquishing responsibilities.
Senator Ridden, your light's on.
No, by mistake.
Okay, that's
Oh, no,
okay.
we're in exec, yeah.
Senator Abbas, go ahead.
So maybe I'm still paranoid.
Okay,
So,
so I wasn't alone. Okay.
well, how was the medical examiner, it not only would have to make a personal inquiry, but they don't have to view the body? I feel like in order for them to make that determination, I guess how are they, I'm not an expert on being a medical examiner, but I would assume there's going to be circumstances where how do they not do it? I understand if, the person was in a fatal single car accident, I
Sure.
understand you might be able to do it because it's very obvious, but I feel like removing that requirement, I mean, again, they still, I mean, I don't know, they
Yep.
don't do it.
Here you are at the
I don't
nursing
know.
home.
I'm just saying,
Right.
how are they doing this without examining the body?
Senator Ridden.
I agree. And when I asked that question, the response was actually in inquiry and a paperwork response as opposed to a physical viewing of the body. And that was looking at the medical history, making some assumptions about the person's age, medications that they were on, how they were found, whether it was at the bottom of the basement stairs, what happened. But the assumptions are not necessarily made by somebody with medical qualifications. The assumptions in the report to the medical examiner's office is maybe a police officer that arrives on the scene that's relaying that information. If nobody from the medical examiner's office comes, that's the source of the information.
Would the committee be more receptive to a re-refer motion? They could come back and talk to us next year. Okay, we will wait on this one then. I'm going to withdraw my motion. We're going to move on. Thank you. 261,
Just
custodial interrogation.
261.
Yep. I have a motion for re-refer. Do I have a second?
All right, waiting a little faster. Okay, so your motion is to
Re-refer.
Re-refer,
The
okay.
custodial interrogation, and hopefully they'll tighten it just to custodial interrogations in the room, make it a lot tighter.
I don't have a problem with that. There was a lot of
Yep.
issues.
Okay. Senator Ridden?
I'm fine with re-refer.
Okay,
Yep.
thank
If
you.
it's not ITL, then I'm fine with
No, it's
re-refer.
re-refer, yep. All in favor of the re-refer motion?
Aye.
Opposed? None. Motion for consent?
So moved?
Second.
Okay, all in favor of the consent motion?
Aye.
Senator Ridden?
Sure.
Thank you.
61.
Okay.
Re-refer.
290. It's relative to the definition of torture. I'm making a re-refer motion. Do I have a second?
Second.
290.
I think this was one of the most difficult public hearings that I've sat through. It really was, and with the exception of today, where there was some testimony that was difficult. And when I went back and looked at what they're proposing fits in the statute, it's one of the worst written statutes I've ever seen in my life. Cruelty is defined and then used as an adjective in most of the rest of the statute, including to describe torture. So everything that was asked for in that bill exists already, just really badly formatted in the existing law. I think it's a rewrite of that section of the statute. It has everything they need. It's just hard to find it the way the statute's laid out.
I also think what they intended for that to apply to and what it actually would apply to were two different things. I think it went way beyond what they wanted, and then if we were to work on this and come up with something, I think there was a lot of interested groups that were, I think we would want to kind of discuss that with all involved, if we were to actually try to fix the bill or make it apply as intended.
I'm gonna have a 5-minute recess at this time.
Do we want to at least vote?
No. No, I'm gonna have just a quick
Okay,
recess.
sure, okay.
We're in recess for 5 minutes. Thank you all.
They're swimming. That's a great line. I'll be right back.
Session with my mic on.
Second.
Motion to go into executive session. There you go. Second. We're going to start with 290. Do I have a motion?
And motion to re-refer?
Second.
And I'll second.
Any discussion?
290. Oh, we're back to that. Yeah.
No
I think we
discussion?
did.
Seeing none? Or,
I will say that I am happy to re-refer and hope people are gung-ho about working on this, but it appears to need a much more comprehensive look than just the portion that this bill addresses.
yeah, those are mine. Thank you, Senator. On the motion to re-refer, all in favor?
Aye.
Opposed?
Move for consent?
Second? All in favor?
Aye.
I'll take it up. Okay, we're going to 261 custodial interrogation. Oh, we did? Jeez, we're moving
What
some-
about Senate Bill
139?
Yep.
Do I have a motion?
Mr. Chair, I move re-refer.
I'll second. Discussion? Seeing none, or you need a minute more, Senator? Okay.
Give me 1 second. There we are. Okay, private right of action. We had. And what was your motion?
Re-refer.
Re-refer.
No discussion?
No, thank you. Do you have any? No. Okay.
She said. Are we all set?
All set?
Okay. On the motion to re-refer, all in favor?
Aye.
Opposed?
Move consent.
Second.
Okay, all in favor of the consent motion?
Aye.
Senator Adams, you want to take it up?
Yes.
Okay. And 146, my last one, correct?
Yes.
I have motion ought to pass.
Not to pass.
Second.
Thought we were just gonna re-refer that 2 seconds ago.
Things changed, quick place.
Apparently.
Any discussion?
Yes, we just talked about how that when we don't lay eyes on a body and you rely on what was testified to, the, PCPs, we open the door for situations like what happened at Catholic Medical Center, which was so egregious, the Boston Spotlight team had to get involved. And when we rely on nursing homes and to give their first look while we're not going to assume nefariousness, the whole reason we have a medical examiner's office is to lay second eyes on a body. There's supposed to be a check. There's supposed to be a balance. This is, I think this is inviting the situation that made us get to having one of these in the first place. We're just looping back around. This is,
Any other discussion? Senator Reardon, you all set? Okay, I make a motion, how do you vote on the ought to pass motion? All in favor?
Aye.
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 Nay.
Nay, okay, 4-1. Senator Adams will take it out. You don't have to.
Mr. Chair, if I
Yes.
may,
Motion for,
we have amended the consent calendar, so even if
Yep.
it's 4-1, that if the person who was the one
Sure.
will consent, it can go on the
Sure.
consent calendar.
okay, motion for consent.
Okay.
And you'll
Second.
Okay, all in favor of the consent motion?
Aye.
Aye.
Okay. And I think we have them all done. Okay, motion to move out of exec.
Balance.
Atlas. Motion to move out of executive session.
So moved.
Right.
Okay, sorry to keep all you other good people. 44. Thank you.
Where is my testimony?
Okay. Senator, yes, anytime you're ready, will be a great time. Thank you.
Good afternoon, Mr. Chair and committee. My name, for the record, is Senator Deborah Altschuler. I represent the Seacoast communities of Exeter, Hampton, Northampton, Hampton Falls, Greenland, Rye, and Stratham. Today, I'm introducing Senate Bill 144. In 2016, the Supreme Court ruled that a newly enacted law prohibiting the state from sending mental health records to the FBI database was unclear, and the court denied a request from the AG to the next database. Senate Bill 144 has one intention: to close the current gap in our law. This bill is language some of you have seen in the form of House Bill 1711 from 2024. There is no change to this. Senate Bill 144 is the same because the language was carefully written with input and review from the Attorney General's office to make sure it complies with applicable state and federal laws that would actually authorize mental health reporting data to be reported to the FBI firearms background check system. Input came from mental health advocates, including New Hampshire hospital staff, NAMI New Hampshire, the New Hampshire Disability Rights Center, and the New Hampshire Psychiatric Society. Their concerns are not only reflected in this language, in many cases, their specific recommendations for wording have been included in this bill. This bill has three major parts. First, it authorizes the New Hampshire Judicial Branch to be the single reporting entity to the FBI's National Instant Criminal Background Check System. Second, it authorizes the court to report only people whose cases have been adjudicated by the courts under three separate circumstances, which are cases involving involuntary mental health commitment, cases where a person accused of a crime has been found not competent to stand trial, and the court has found their illness could make them a danger to themselves or others, or when a person on trial has been found not guilty by reason of insanity. Only people whose cases have been adjudicated by the courts, precise procedural circumstances would be reported. This bill does not sweep up anyone and everyone who has ever been treated for a mental illness. This bill does not apply to people who are voluntarily committed or people who are being treated for a temporary mental health trauma. At the request of the New Hampshire Disability Rights Center, privacy provisions restrict what data can be shared, which will be a person's name, social security number, birth date, and reason code for a person's treatment. No other information is to be shared. Under the bill, simultaneously with adjudication of an individual status, a judge would have discretion to order a person to relinquish their firearms and ammunition to law enforcement, or transfer them to another person, or to order them confiscated by law enforcement no later than 48 hours after the order is issued. Third, this bill is a process to restore a person's firearm rights. This relief from disability provision gives a person prohibited from purchasing or possessing a firearm under the statute the right to a hearing and the right to legal representation within 60 days after a petition for relief has been filed. Also included is a requirement for completion of an independent psychiatric evaluation. Our obligation to protect public safety should never be a license to stigmatize or discriminate against people with mental illness. Our obligation to our constitutionally enumerated natural right to enjoying and defending life and liberty should not be a license to turn a blind eye to preventable danger. There is a balance to be achieved. Article 3 of our Constitution, unchanged since 1784, addresses in the society, its organization and purposes. When men enter into a state of society, they surrender up some of their natural rights to that society in order to ensure the protection of others. And without such equivalent, the surrender is void. Established on June 2nd, 1784, we were never meant to be all rights and no responsibility. I acknowledge that this is an uncomfortable issue for all of us, and for different reasons. I also believe, I truly believe, we can enter into meaningful discussion in good faith, recognizing that the roadblocks of yesterday may not be the same today. Additionally, while our personal experiences certainly inform our viewpoints, our job here in this sacred space we have been sent to by thousands of Granite Staters is to do the most good for our state. In the last few weeks alone, this committee has seen fit to make quite a few incremental changes to our laws in the name of violence prevention and public safety. Let's apply that same energy here. I am attaching data collected by the Pew Foundation, the Bureau of Tobacco and Firearms, and the Department of Defense. The number of firearms in this country is at an all-time high. And while it is not the topic here today, we have been in this discussion before. So let us all stipulate that this bill is offered at face value, no hidden agenda, and in good faith to do the valuable prevention work this committee has done this session already and can continue to do. Additionally, it saddens me to have to clarify this, as a previous accusation had cast aspersions on one of the assemble of supporters I presented in Senate Bill 144. With sincerity and in an honest try to prevent future tragedy, I hope to prevent this discussion from devolving into finger pointing. This bill brought people together who had open minds and challenged beliefs. Groups who espouse their unwillingness to engage in discussion of what may be possible, who use the phrase uncompromising as a recruitment tool, or who have repeatedly refused to approach or engage in good faith discussion on this topic in this chamber, were not sought out for their opinions as they are well stated to date. I have been labeled a gun grabber, and that could not be further from the truth. I should not have to disclose the make and model of the firearms in my home to gain entry into this conversation. It's a juvenile approach to a deadly serious public safety discussion. We remain open to future discussions should those groups choose to, as we say, come to the table. The safety gap in our laws, being the non-reporting to NICS, may have already cost the life of a man whose life was devoted to public safety. Gun violence is not abating, and the numbers grow. The Attorney General's report on what happened at Concord Hospital was released, and on page 24, it enumerates what happened when the perpetrator went to buy a firearm at a federally licensed firearm dealer in this state. They lied. They lied on the application, and the firearms dealer followed all the rules. The firearms dealer did their job, but we didn't. We aren't putting the information into the system. And had that information been in the system, it would have been flagged. And that purchase could not have happened, but it did because we don't put that information in the system. We could have prevented a death. There is a clear evidence on page 24 of the Attorney General's report that we could, had we had this in place prior, prevented that death, prevented the sale of that particular firearm. I ask you, my colleagues, with deep respect for our constituents and in good faith, with the strongest possible urging, to please give Senate Bill 144 your full support with an ought-to-pass recommendation. I've added notes to the end of my testimony to support some of the assertions I've made in it, and I am happy to take questions.
Thank you, Senator.
Although I will grab I have my green folder because I don't have the bill in front of me, if you wouldn't mind. Thanks.
Oh, wait till you have it in front of you.
I have my testimony, not the actual.
Oh, okay.
Thank you.
Thank you, Senator. On page 2,
Yes.
it talks about, they're gonna, let's see, the court shall inquire of a person if he, she currently owns or
What
has
line are,
access.
I'm sorry,
Line 15.
15, thank you.
Yeah, on page 2. So it's talking about, you'd have to disclose you had the firearm. So 2 questions. One, is there a legal duty for the person to make this disclosure, whether they have guns or not? And B, at this time, do they have the right to counsel at this point? Or do they have access to counsel? You're taking away
So
the
this is at
Second
the,
Amendment right. So do they have right to counsel would be my second question. The main one, are they under a legal duty to disclose that they either have firearms or access?
thank you for the question. So this is an official hearing under the courts. Everyone's sworn in. So they have an official duty to tell the truth.
Do you see any possible self-incrimination problems there?
Well, when we have a domestic violence order that is placed, you are asked to disclose where the firearms are. So we do this already.
Okay. Are you aware there's a Supreme Court case? I can get you the exact site, but it's the Haynes decision, and it affirmed an individual's right to not self-incriminate due to firearms ownership. I didn't know if you're aware of that case.
So
Anyways,
I think
you can
I'm a
look
little
into the case.
confused as to the self-incrimination because it's not a crime to own the firearms. It's what.
Well, am I under, are they, you're saying they're under a duty, an affirmative duty to disclose that they have, if they don't say anything, then can you prosecute them for something? Or
Well,
what if they don't answer? They don't
yeah,
tell you?
may I answer the question?
ma'am.
Okay, so it's a court hearing. You're sworn in. Everybody's under a duty to tell the truth during that hearing. So, I mean, this is,
You're under a duty to tell the truth.
Tell the
But are
truth.
you compelled to, what if you had a stolen gun? I don't know. There could be a whole bunch of hypotheticals. Are you under a duty then to do something that could be self-incriminating?
I'd like to draw your attention on page 2 up to line 9, part 3. If a court determines that a person is not competent to stand trial and finds that the person is also a danger to themselves or others, that's, we're concluding. And at the conclusion of that determination by the courts, then you are asked, where are they?
Going to move on to another line of thought.
Sure.
So now I've voluntarily relinquished, give me 1 second.
Sure.
During that time, so they give you're giving the person 2 days, right? The court could find you have 2 days to give up your weapons. So this is a person that's either been found not competent or they're dangerous. Do you find it funny that you're sending them out, we're saying we're going to take your guns, which is probably going to piss off a lot of people in this state, and then you're going to give them 2 days with access to their weapons before they could, shouldn't it be an immediate thing? Do you see a danger here in giving them 2 days?
So there's also the option, they may not be released. So, and the option is to have another person, a trusted person of their own,
Can I
go get
follow up
them.
one more thought on this line? So
Sure.
we have a dangerous person out there.
But
There's
we don't know
fires.
they're out there. I just want to back it up. We don't know they're out there. They may be deemed incompetent and dangerous, so they may be held. We cannot assume that they are just going to be released.
If
That
they-
is
So
not
you're
the
saying
assumption.
that you're assuming if they're charged
I'm
with
not assuming
dangerous-
nothing.
Okay.
I'm
So they could be,
assuming nothing.
the way the bill's written, they
Yes.
could be released. And then if they're a danger, they could take a car and drive it into a crowd. They could do tons of stuff. I don't see that we're dealing with the mental illness that I'd like to deal with. We're just saying the guns are the evil thing. And we're letting dangerous people possibly out on the street and not taking away their knives or their, most crimes with guns are done by stolen guns. So the odds of these people then, 89% or something of the crimes that are committed by guns are stolen or otherwise taken guns, not people's personal guns. So if the person's the danger and not the gun, aren't they still gonna have access if we leave them out there? Or are you saying we should, anybody who's at all dangerous, we should lock them up?
Wow, that's a lot. So
I can
you've
rephrase.
inserted assumptions and into my argument that do not exist. So I'm going to try to go through
Okay.
them. One was that everyone immediately gets locked up. That is not the case. There is judicial discretion there. Second, I think that, they could have knives and so on and so forth. We know that firearms are the most lethal weapons available for someone to cause harm to themselves or others. True fact. So we are looking to make sure that we are reporting this information to the NICS background check system. We are reporting nothing. And if we had reported this, then the person who shot our security guard at the Concord Hospital would have been impeded from buying the firearm that he was allowed to buy legally because our laws leave a gaping hole. We're just trying to close that hole. Nobody's saying that you can't continue to buy firearms, just that some people who have been adjudicated through the courts as incompetent should not be have the ability to continue to have access to firearms and ammunition. It's a small segment of the
One last question,
population.
if you'll take it.
I will. I'll take all of them.
Okay.
Yeah,
Thank you.
let's go.
Thank you. At the beginning, last year, the bill had talked more about evidentiary standards at the
The
beginning.
bill is the same.
Oh,
No
I thought there was
changes.
more, we talked more about evidentiary standards.
We may have talked
Maybe we
more
just
about it.
talked about it. So at the beginning, when you're at an involuntary commitment hearing or something, I believe it was preponderance of the evidence standard to take it, like 51%, correct? Before they could get you to the next, because it's a quick thing, quick hearing, and they don't have time to really build the case.
What line are you looking at, sir?
No, it was more discussion we had, we
So not
spoke
a
a lot about
specific line.
evidentiary standards.
Okay, we're not looking at a,
Okay, so I thought when you're seizing the weapon, it's a quick hearing, they only needed a preponderance of the evidence to get us to this next phase. And then at the end of the bill, it talks about a clear and convincing standard. So my thoughts are, you're taking the guns away with 51% evidence, but for me to get the guns back, there are methods in this bill to go to an appellate hearing, like within 6 months. And then after the 6 month, if you were denied, it was 2 years, I believe, at the end of this bill. So a very high standard to say I'm now competent by clear and convincing evidence. I would think if I could prove by preponderance of the evidence that I'm seeing, because it's going to be very hard to prove you're not a danger. You're like trying to prove a negative. How do you know you're not? So I'm a little uncomfortable with your clear and convincing evidence standard to get the weapons back.
Can I answer? I'd like to clarify, Senator Gannon.
Thank you.
That this bill authorizes the court to report to the National Instant Criminal Background Check System only people whose cases, so they are involved in the court system already. Their cases have been adjudicated, so they have already gone through the process. and they may or may not have counsel appointed by the state, because we are at the end of the process now. We are looking at 3 specific circumstances that apply after a case is adjudicated. Cases involving involuntary mental health commitments, cases where a person accused of a crime has been found not competent to stand trial, and the court has found that their illness could make them a danger to themselves or others. And third, when a person who is already on trial has been found not guilty by reason of insanity. We are talking about reporting to the NICS background check system these 3 instances of people who are already adjudicated. We're gone through the process. This is not an arrest off the street. This is not someone picked up having a mental health crisis on the, at their home. That is not applicable in this bill. And as a matter of fact, the reason that it is not applicable is that we tried in good faith to meet those objections and find that narrow space where we can use these 3 specific, limited circumstances that are post-adjudication to put that information into the criminal background check system.
Thank you, Senator. Any other questions? Senator Abbas.
Thank you, Mr. Chairman, and thank you for taking my question. I'm referring to page 2, lines 15 and 16. And I raised this concern last year, and for the intent of the bill, I certainly understand it would apply to any firearms a person owns. But why does it have the language "or have access to"? Because the way I interpret that is a person who is not subject to the pending court case, who's not involved in whatever's happening in the legal system, they could be the person who owns the firearm, but because that other person has access to, from the way I read this paragraph, that firearm is still to be surrendered.
So before the close of the hearing already conducted pursuant to RSA 135, 17, 135C 34 through 54, RSA 135E5, or RSA 172B2. Those are 4 specific instances. The court shall inquire if of the person, this is at the close of the hearing, if he or she currently owns or has access to any firearms. And so, where are they located? Because people who have access to firearms and have been involuntarily committed for mental health reasons, have been accused of a crime and found not competent to stand trial, or have been found not guilty by reason of insanity, the idea is to keep them away from doing harm to themselves or others. So having access, it doesn't matter if you go in, if you're being released into a home and you may not have ownership, but the place you have access to them, that access needs to be limited.
Oh,
And there are multiple ways to do that.
I understand what your answer is, but as written, it does say if the person answers affirmatively, that the court shall inform the person that it says may order law enforcement to confiscate those firearms.
May, not shall, may.
But I guess my point is, in the event that were to happen, and I understand, obviously, the access can change pretty quickly, but if those firearms are not owned by the person who's been deemed, not guilty due to insanity, they don't own the firearm that they're being ordered to surrender. And that's one issue. But the other side of the issue I have with that is, well, if I own the firearm, but I'm not the one that's been found, I'm not the one on trial, I'm not the one that's being charged with the crime, I'm not the one being found not guilty by means of insanity, technically my property interest in something is now being surrendered to a court on a case I'm not even a party to. So I'm just wondering why the access to language has to be there. And then I guess if you're amenable to taking it out, my next question would be, I know in the back end, I believe last term, the prime sponsor in the House believed that this would be certified by ATF. I wasn't clear if we changed that provision, would they still certify?
So I'd like to answer your question. Given the objections that we have tried in very good faith to meet, to create a situation where we are ensuring maximum public safety, this bill was rewritten to meet your objections. And if we continue to read on line 16, if the person answers affirmatively to the question, do you own or do you have access to firearms, the court shall inform the person that the court may order law enforcement to confiscate those firearms or ammunition. In addition, and this is very important, the court shall offer the opportunity for the person to make voluntary arrangements to relinquish possession of those firearms to law enforcement or to someone else who's not a prohibited person. So understand that if we are talking about somebody who lives in the home these are three people who all live together. One of them owns firearms. One of them is in acute mental health crises. We are making the leap that the other people in that home want to help that person. They want to be safe altogether. And so to meet the objections that we have gone around on this one, the year before and the year before that, we are setting up a system. We are giving those people in that home, what can you do to help keep everybody safe in this situation without putting that person who's in acute mental health crisis, who may go home or may not. If they are going to go home, how do you want to keep them safe? The courts may give you the opportunity to say, do you have a friend that we can place these firearms with temporarily? They're still in your possession. You own them. They're just in a different space. They're next door. They're at Grammy's house. They're at your brother's house. You can store them in any. We did not say they have to be stored at a federally licensed firearm dealer, which I will remind the senator, we have proposed that prior, and oh my God, you would think that that the roof was falling in. And so to meet that objection, how about we offer that people can give it to a loved one, give it to a friend, give it to a trusted individual. So we're meeting those objections. So I'm hoping that the objections you're bringing up now also incorporate that there's an affinity within that house of people who want to keep each other safe.
Still, last one.
Well,
It's not the affinity. I agree with you. I would hope that a household would take all the safety precautions, irregardless of the order. But what I'm saying is there is a person who's not a party or named in the suit that is now subject to a court order. And if it's a criminal case, do they even have a mechanism or any standing whatsoever to challenge that? They're now ordered to act as well, is from what I'm hearing, but they're not the one that's subject to this. Well, they're part of the order, but they're not named as a party in the case. So think of it this way. If it's me and my colleague to my left, we're the parties. Why would my colleague to my right now have to act under the court order? They're not named as an interested party in the suit. So what I'm getting at is the access to part could have some collateral consequences. So what's the mechanism that person has? That's my concern with the access to. So how do we address that?
Senator Abbas, if you are living with Senator Gannon and you are experiencing an acute mental health crisis and you have been deemed incompetent to stand trial, or you have been subjected for involuntary mental health commitment, and and you have the court has the opportunity, has brought you to a place where you could possibly go home, and Senator Gannon says, I'm not going to move my guns out of the house, then I might, as a court, we might have to release you somewhere else. If the people in your home are unwilling to do what it takes to keep you safe by moving their guns next door, not relinquishing them, moving them out of the house. I don't know what to tell you at that point. I hope that we would refer back to our Constitution, where we agree that when we enter into a state of society, which if the two of you are living together, you have agreed to a state of society, that you would surrender some of your natural rights to that society in order to ensure the protection of others. It's in our Constitution. We wrote it into the Constitution that we care about and will take care of each other and provide public safety. We are not all rights and no responsibilities. We have responsibilities for the public safety. And so this bill gives so much latitude in making sure that someone still has access to their property without it being confiscated, but ensuring the public safety, ensuring that those natural rights are still in service and ensuring the protection of others. I wish I could, I wish that I could restate Article 3 in 14 different ways so that it might hit in a way that lands in your heart. That is what I am hoping. But I don't have those words because I think that Article 3 is pretty well stated.
Can I just follow up a little more on this? I understand where you're coming from more with someone living in the same household, but then you get to big families, brothers, sisters, who may all have access to each other's houses. So now you're saying the court could take the firearms from any of those houses that I have access to, leaving many, many families without any protection.
That is a wide interpretation that I do not see reflected in the language in any way. I think that's projection.
You can go ahead, Sally.
Thank you, Chairman Gannon. I want to just look at the language that we're talking about right now on lines 18 through 20. On page 2. Apologies. Yep. In addition, the court shall offer the opportunity for the person to make voluntary arrangements to relinquish possession of his or her firearms to law enforcement or to another individual in accordance with paragraph 3. If those are firearms that they don't necessarily own but have access to, isn't in fact the court giving notice to somebody, especially in terms of when we've seen a high school student access a gun of a parent, being on notice to the person who does have those guns that this individual may have access to, that they bear some of those responsibility, some of that responsibility about access. It could mean changing the combination on the gun safe or something like that. But I think in this case, especially in light of the liability that we've seen of surrounding somebody that's having a mental health crisis, when you know they're having a mental health crisis, and in fact, you know they have access to guns, they know where the guns are kept, that there's some responsibility here for the court is recognizing that access to firearms is as deadly as owning the firearm in this case. Would you agree?
I would agree, and that is further enumerated in section 3, where the court may simultaneously, with any order of commitment, issue an order directing the person to make arrangements to voluntarily relinquish possession of any firearms or ammunition he or she owns to law enforcement, directing the person to transfer any firearms to another person with whom the person does not cohabitate, different house, who is not himself or herself a prohibited person, and to whom the court determines such a transfer would be permitted. So if you want to move your firearms over to Grammy's house and Grammy can lock them up at her house, then the court would be okay. Just move them so this person who's in acute mental health crisis, adjudicated by the courts, not to be able to have access, not to be able to buy any, not be able to have access to any, not be able to buy ammunition because they're dangerous to themselves and others. And we have constitutional right to safety. And also directing law enforcement to confiscate any firearms owned by the person no later than 48 hours. So you've got 2 days to figure out where we can move this so that they are not a danger in the home. You got 2 whole days to figure that out. And the reason that's in there was that we had proposed immediacy, and you would have thought we had set everyone's hair on fire. So to meet those objections and to find a good faith space where we could agree, you've got that in there.
Thank you, Senator. And seeing no other questions, you have a good day. Thank you.
Thank you.
No questions. No problem. Holly Stevens. Good afternoon, Ms. Stevens.
Good afternoon, Chairman Gannett, members of the committee. My name is Holly Stevens. I'm the Director of Public Policy at NAMI New Hampshire, the National Alliance on Mental Illness. On behalf of NAMI New Hampshire, I'm here today to offer cautious support for Senate Bill 144. At our legislative breakfast a couple of weeks ago, we were asked why NAMI New Hampshire was offering cautious support for a bill that would impact a constitutional right of someone with a mental illness. Rather than summarizing my written testimony, which you have, I want to answer that question for you. But before I do, I wanted to talk about the 2 days, if you wouldn't mind. The reason that we talked about having 2 days, NAMI New Hampshire felt it was important, was because when it comes to people who are on an emergency admission, involuntary emergency admission, they're going to be in the hospital for a minimum of 2 days, which is why we felt 2 days was important, because they would not be in their home when law enforcement potentially showed up, having a confrontation between them and law enforcement that could end up deadly. We feel this bill is important because of the impact it will have on preventing suicides. Approximately 85% of all attempts made with a firearm are fatal. Firearms are the most common method used in suicide attempts. And in the Granite State, 87% of all gun deaths are suicide deaths, and that's compared with 56% of deaths in the rest of the country. And I also wanted to talk with you about the IEA process, just so there's an understanding of when this is triggered in the involuntary emergency admission process. You first have the petition that's completed by the petitioner and the medical examiner. It's signed by a judge or a justice of the peace. This bill does not impact those folks when they are first taken to New Hampshire Hospital. They are to be held there for 72 hours. And during that 72 hours, they have to have a probable cause hearing. During that probable cause hearing, the court determines whether there's probable cause to hold the person for up to 10 days. If the court finds, and they've got counsel during this hearing, if they find that there's probable cause to hold them for those 10 days, this bill doesn't affect those people. If after 10 days, the people in the hospital personnel feel that the person needs to be held for up to 5 years due to their mental illness, danger to themselves or others, then there's a probate court hearing where they're also represented by counsel. And it's after that probate hearing, that second hearing where they're represented by counsel, where this would take effect. So the first 2 sections of this process are known as the assessment and evaluation process, which is not affected by this bill at all. Also, at any time during the IEA process, a person can decide to go voluntarily and change their status to voluntary. If they do that before this probate court hearing, then this bill would not affect them. And so there's been an argument that this will keep people from seeking treatment, and it won't keep people from seeking treatment because anybody who goes voluntary or changes their status to voluntary before that probate court hearing, it doesn't affect them. And so in closing, I just want to encourage you to read the first page of our remarks about the things that we believe are important to have in this bill for protections for people with mental illness. And I'll leave it at that and answer any questions that you may have.
Thank you for your testimony. Seeing no questions, have a great day.
Thank you.
And so we're staying with 2 minutes, if I didn't make it clear. And if you cannot read, we will read. If you have copies or want to get us copies of written testimony, that'll be great. Hope it's not from me. Simona Thurber.
Hi, my name is Simonida Thurber, and I'm from Exeter, and I represent myself. Honorable Chair, members, and members of the committee, according to the current federal law, people who are involuntarily committed to a psychiatric facility are already prohibited from possessing or purchasing a firearm. However, New Hampshire currently does not report those cases to NICS, or the National Instant Criminal Background Check System, thus making national firearm background checks inaccurate, incomplete, and ineffective. This Senate Bill 144 would close this glaring and dangerous loophole. When last year's version of a similar House bill was being considered in 2024, Governor Sununu supported the passage of the bill. According to the NHPR article from May 17th, 2024, which I referenced at the bottom of my testimony, Sununu said, "This is clearly a loophole that has to be closed, and I'm supportive of the bill." We know during Governor Ayotte's previous service in our state as Attorney General, she was then and is still now dedicated to public safety. A dedication to public safety and the law enforcement agents who deliver it demand that we join 47 other states who prioritize public safety with full and complete reporting to the National Instant Criminal Background Check System. So please vote in support of the Senate Bill 144. Thank you.
Thank you for your testimony. Seeing no questions, have a great day. Oh, I'm sorry. Do you have a question?
no,
Your hand went up. No, we're good. You're playing with me here.
Let me see.
Elaine Kennedy. Good afternoon, Elaine. You're raring to go.
Thank you. I'm here. Press the button. Again. I'm here. Yes, I am here to talk about the intense pain that occurs. I'm a pediatrician, have been for 50 years, and I am a family member, a mother of 2 adult children with very serious mental illnesses. I'm going to talk about the intense and lasting pain that comes to families when death by bullet occurs. This is a true story. Picture an April morning. There's an 11-year-old boy on the front lawn. He's not waiting for, this was last April. He's not waiting for the school bus. He's waiting for the police. He has dialed 911 because the 5 members of his family inside were dead from gun bullet. Okay, father, it was covered well in the newspapers in Oklahoma City. The father had been with his father at an Oklahoma Thunder game the night before. Came home, nobody knows what snapped. But now we have 5 people dead, 2 adults, and 3 of the 4 children are dead. The news coverage did say that he was a very good neighbor. Everyone was loved in the neighborhood, as were the children. He had told a friend that he had some depression. the parents of this mentally ill 41-year-old had no idea of how serious this illness was. How do I know that? This shooter's mother is a very dear friend of mine from Oklahoma. I see her daily on a Zoom group that we have for support for mental health and spiritual growth and support. We've known each other for more than 4 years, and the emotional pain in her and their family will never end. I had a mother in my office when I was discussing with her gun safety, gun sense as for gun owners. She said, there are no guns in my house because I have depression and I will not let guns in my house. Brain illness is in my family. I did say that. My younger sister has serious dementia. Dementia people protect themselves with their guns also, but frequently they shoot somebody that's actually a family member. This is not the legacy that you want to leave your grandchildren. Oh yeah, grandmom or granddad is the person who murdered the neighbors or murdered my aunt. No, that's not what we want. People have mental illnesses in families. There was a very brief anger episode with one of my children, and I made arrangements to meet with the police because they knew about it, and I met with them. The first thing they said, are there guns in your home? I said, no. There are not guns around my mentally ill children. My mentally ill children are wonderful, high IQ, productive human beings, and they are alive. My friend's son and 3 of her grandchildren and her daughter-in-law are dead. So I want to support what helps families, and I know families want the help and support of the people they elect. It's very difficult to have to deal with situations when you have adult mentally ill children. Families want help. Thank you.
Thank you for your testimony. Seeing no questions. Lena Nurk. Afternoon, ma'am.
My name is Lana Nurk, and I am testifying in support of Senate Bill 144. Screening gun buyers with a background check is the backbone of any comprehensive gun violence prevention strategy. Since its inception in 1994, the background check system has blocked millions of sales to people prohibited by federal and state law from possessing guns, including convicted felons, domestic abusers, and people prohibited due to mental illness. But the federal background check system is only as good as the data it contains, and the data is largely submitted by the state courts and law enforcement agencies. States' failure to submit records have enabled prohibited people to pass background checks. The devastating results of states' failure to report includes the mass shooting at Virginia Tech, where 32 people died and 17 were wounded by a shooter who passed 2 background checks, even though he was prohibited from possessing firearms due to a court judgment that he was a danger to himself and others. Since the 2007 shooting, most states will send records to the federal database if a person is found not guilty of a crime by reason of insanity, found incompetent to stand trial, or involuntarily committed to a mental health facility. New Hampshire remains one of 3 states that do not submit these records. In addition to authorizing reporting, SB 144 contains a relief from disabilities petition process that can result in the mental health records being removed from the federal database once the person has demonstrated that they are no longer a danger. Overall, Senate Bill 144 is a reasonable, common sense effort to improve safety in New Hampshire communities without infringing on Granite Staters' rights. Thank you.
Thank you for your testimony. Kimberly Morin. Good afternoon.
Good afternoon. Before you start my timer,
The Supreme Court of the United States ruled that just because someone is a prohibited person, the other people in the home don't lose their rights. You have to, by federal law, you have to lock up the firearms. They don't have to leave the house. You can still have them. So now you can say. By the way, I'm Kimberly Morin. I represent the Women's Defense League of New Hampshire. I represent women across all of your districts across the Granite State. This bill is an emotional, knee-jerk reaction to the horrible murder of a former law enforcement officer turned unarmed security guard at the state psychiatric facility. There is nothing in this bill that would have prevented that tragedy. There is nothing in this bill that stops violently mentally ill people from committing criminal acts against their innocent victims. There is nothing in this bill that will stop someone from committing suicide. This bill intentionally discriminates against gun owners. There are many cases of criminal acts committed by the violently mentally ill where firearms are not the object chosen. Why aren't matches, lighters, knives, automobiles, pressure cookers, or other objects being confiscated as well? The families of the people who have been murdered by violently mentally ill people using these type of objects disagree with these objects being less lethal than firearms. Gun control laws such as this one do not stop criminals from either getting firearms illegally or from using other objects to commit violent acts. A U.S. Department of Justice report from 2016 shows that a majority of imprisoned criminals obtain their firearms illegally. This bill does nothing to stop that. This bill does nothing to stop violently mentally ill people from committing any crimes. If someone is violently mentally ill, why aren't they staying in a facility? Why aren't they staying in a safe facility where they won't harm themselves or others? This bill does nothing to stop those who are suicidal. Those who commit suicide also commit suicide in various ways, not just with firearms. And as already stated, this bill does nothing to stop someone from getting a firearm illegally. What this bill does do is point the finger at gun owners. The reality is the finger should be pointed back at the psychiatrist who pushed to shut down all the mental institution a couple decades ago, and the state of New Hampshire for doing nothing to remedy or solve the actual issue in regards to violently mentally ill people. I'll be really quick. Suicide is trending down, which is awesome, and I think that's from people getting more information and receiving help that they actually need. I just also want to note that the majority of those with mental illness are more likely to be victims and not criminals. Please vote inexpedient to legislate on this. Nothing is being solved with this bill. It won't stop either crime or suicide. We really, really need to resolve the issue of having more mental health facilities to protect people so they're safe and society.
Thank you very much. If you want to drop off your testimony.
No.
We can get to ours. Okay.
I'll write you guys emails.
Thank you. Bonnie Downey. Okay. Lorraine Whittington. Yep. Thank you. Pete, this is the only page? Okay. Good afternoon, Ms. Whittington.
Good afternoon. Thank you very much for taking my testimony. My name is Lorraine Whittington. I live in Durham, New Hampshire. We hear all the time, and I'm here in support of this Senate Bill 144. We hear all the time that guns don't kill people, people kill people. Senate Bill 144 is a bill that would ensure people with significant documented mental illness or incapacity are prevented from accessing a gun which could be used to harm themselves or others. According to a Pew Center research report, this is the kind of measure that enjoys strong bipartisan support. The NICS reporting system works. In another state years ago, a close family friend had a significant mental health crisis. This crisis was reported to NICS, which in turn prevented him from purchasing another gun after his guns were removed from his possession. Because of this reporting, his wife was able to protect their family. Today, this family is celebrating birthdays, anniversaries, graduations, and weddings. Joey is still hunting with my husband. They had the chance to heal without the threat of gun violence. This is just one example of how NICS saves lives. Lena referred to the tragedy at Virginia Tech earlier. It was another case where the absence of this kind of reporting that this bill provides would have basically averted the deaths of 32 people, injuries to 17 others. It was a preventable tragedy. John Medore had his guns removed by a court order in this state. He was able to purchase a gun through a licensed gun dealer in this state, not only because he lied about his background, but because our state did not alert NICS of his disqualifying history. He used that gun to senselessly kill Bradley Haas, a man he had never met. This bill would make it impossible for anyone as unstable as he to purchase a gun in New Hampshire. The system of gun violence is vast, yet time after time, the desire for a perfect single solution causes a good attempt to fail. Let us not once again make a quest for that single perfect solution to the problem of gun violence become the enemy of the good. For these reasons, I'm demanding this legislature recognize and vote yes on Senate Bill 144. Thank you for your time.
Thank you for your testimony. Seeing no questions. Thank you. And Pete, did you have that other sheet? Did you bring it over? I don't see. Okay, sounds good. Sounds good. Anyone else wish to testify? Maybe I missed you. Maybe you're on the other sheet. Who knows? Come on up. State your name. Thank you.
Thank you, Mr. Chairman and committee. My name is Kate Giddens. I serve as the State Director of Women for Gun Rights here in New Hampshire, and I'm here today to strongly oppose Senate Bill 144, a bill that is not just flawed, it is detached from reality. Its sponsors claim it will prevent tragedy by allowing families, communities, and law enforcement to intervene before violence occurs. But they ignore a painful truth. Tragedies do not happen because of a lack of legislation. They happen because the people and systems responsible for preventing them fail. And when innocent people are left defenseless, they pay the price. People like Chief Bradley Haas. Senate Bill 144 states that Chief Haas died protecting staff and patients that day, but I ask, what was he protecting them with? And what was protecting him? Bradley Haas, son, brother, uncle, father, was stationed at the entrance of a mental hospital unarmed. The state of New Hampshire took away his right to defend himself that day, and he paid the ultimate price. To use his name to strip even more people of their right to self-defense is not a tribute, it's an insult. To truly honor Chief Haas, we need to acknowledge the mistake that cost him his life. It was the same mistake that cost 18 lives in Lewiston, Maine. People were unarmed. We need to learn from this failure, not follow it, by ensuring the next person who stands in Chief Haas's place is given the means to survive. Self-defense does not stop at the door. Red flag laws like this exist in 21 states and fail in every one because they are based on a false premise that legislation can fix a problem that is fundamentally human. You cannot legislate personal safety or force people to care for one another. You can only educate and empower. By teaching loved ones how to protect themselves and others, by practicing safe firearm storage, training to conceal carry, increasing situational awareness, funding mental health outreach, and protecting those who protect us. We fight isolation and cruelty with support and charity. And this is what saves lives. When legislators call on the strength of citizens rather than preying upon their weakness. New Hampshire has always led the way in preserving freedom. Our Governor, Kelly Ayotte, won her campaign on the promise to keep the live free or die state free. Yet some legislators, determined to see her fail, are pushing policies that erode our values and bring us one step closer to becoming like Massachusetts, Maine, Vermont, Rhode Island, and Connecticut, where the strictest gun laws in New England have utterly failed to stop these tragedies. New Hampshire is better than that. Senate Bill 144 is not the answer. Laws like this have already been proven ineffective across the nation, and I urge the committee to be strong in your commitment to our Constitution, to your people, and the way of life, which is not broken and doesn't need fixing. I urge you to once again reject this bill. Thank you.
Thank you for your testimony. Seeing no questions, have a great day.
Thank you.
Anyone else wish to testify who didn't get a chance? Gone. That ends the hearing. Thank you all for your patience. Those are his. That's his.